Good morning. Today is Wednesday, March the 13th, 2024. I hereby call the Property and Planning Subcommittee to order. Madam Secretary, you please take the roll.
Representative Martin. Here. Representative Raper. Here. Representative Reedy. Representative Rudd. Here. Representative Thompson. Here. Representative Wright. Here. Chairman Crawford.
Present.
Chairman Carr.
Here.
Chairman Carr, you have a quorum.
Thank you. Does any of the members have any personal orders before we get started today? Chairman Crawford, you're recognized.
Thank you, Mr. Chairman. Today I have a shadow with me all day. He is from Bell Buckle, and his name is Jonathan Gillette, and he's part of the Tennessee Eagles. Would you please stand up? Make him feel welcome.
Any other comments from the committee? I'll take a personal privilege here. I do have a shadow with me today, Miss Laney Morgan from Stewart County. Laney, if you stand up, please. Laney is goes to Stewart County up there. She's going to go to MTSU, and she's going to be studying psychology. I've got her for a little while. Then I'm going to have to send her back up to Farmer's office. She's going to see a local government. She's going to see some civil and criminal justice this afternoon. So let's all give her a big round of a welcome there. All right. If nothing further, we'll item number 1, HB 2868, has been rolled 1 week. Item number 2, House Bill 1335 by Chairman White has been rolled 1 week. That comes down to number 3 on the calendar, House Bill 2567 by Chairman White. Chairman White, you are recognized. Motion and second. Mr. Chairman, do we have an amendment on this bill?
Let's see, the amendment would be 14716. Does that line up?
That is what I have. Do I hear a motion? I got a motion, proper second. Motion, a second on the amendment. Would you like to place this on the bill, sir, before we get started?
I would.
All right, all those in favor of amendment 14716 going on the bill, say aye. Aye. Those opposed, no. We're back on the bill as amended. You are recognized, Chairman.
Thank you, Chairman Committee. Appreciate this. This bill deals with blighted property or property that is off the tax rolls basically because of disrepair, blight, all the things. So what we're trying to accomplish with this particular bill is get blighted property, number one, fixed up and back on the tax roll. And the way that we do this, we take vacant or disrepaired property where either the owner is absent, you can't find the owner, or else the owner is financially unable to bring the property back up to a status of stabilization, maybe an old house or an old barn or a dilapidated piece of property that needs to be torn down. And so what it does is then the city, county can file a law, put this in a lawsuit once they cannot find the owner or they don't have the means to do that. And the court system appoints a receiver in place of the owner. Now, the receiver is someone who has the money that can then go in and either develop the property or bring it back up to a state of where it's stabilized, where you can then start to put it on the market. So the owner, the receiver he will file a lien for his expenses and bring the property back up, either develop it or stabilize it. And then the property can be put up for sale because now the blighted part is gone. And because of a Supreme Court decision in 2023, the property has to be put up at fair market value before a land bank can swoop in. Because I think in our county we have 13,000 pieces of blighted property, so we don't need another piece in the land bank. But this puts the property on fair market value. This gets the developers that can come in and buy this. And once this happens, then first of all, the tax lien is first. That money goes back to the local community. And then the receiver can claim his lien back. And then the property has been sold and is ready to be developed. The main thing this does is take blighted property and gets it back on the tax roll for the community. And with that is the basic explanation of the bill.
Thank you, Mr. Chairman. I see Representative Thompson, you're recognized.
Thank you, Mr. Chairman. Now I'm assuming, and maybe you can specify when the receiver receives this, is there specific goals or metrics that this person's supposed to meet when redeveloping the property?
Chairman, you recognize.
Yeah, thank you. And from what I understand, having my conversations, and I will continue to this bill advance, continue to have conversations with those, but they're not on the speakers list today.
Sure.
So I had to do my best. From what I understand, if you got a piece of property, say in a neighborhood that's got rundown houses on it or things or commercial property, and the city or the neighborhood preservation association, they can't get a hold of the property owner, or he doesn't have any money to develop to fix it up, then the city can file a lawsuit. That way they can then appoint a receiver that says, hey, I will go in and get this property stabilized back up, and they will file their lien for whatever expenses they have. Now, I think I'm understanding correctly. They could go ahead and develop that property if they wanted to, stabilize it or develop it. And once they stabilize it, when you got rid of all the debris, whereas then a piece of property that somebody wants to buy, and then it goes on the market for fair market value. And the developers can come in, partnerships can come in and take that 1 acre, half acre, 20 acres, whatever it may be, and put it back on the market.
Representative Thompson?
Is it determined this, or do you feel this model will be better than the model that's been there now, the land bank?
Well, and I think I actually worked on that bill a couple years ago. I think we're continuing to modify what we have done to make it work better. You put a piece of property into our government land bank, you still got issues of getting it back on the market. You want to develop this property, and you want to get rid of all the debris or dysfunctional whatever's on that property so that it can be sold. So the basic thing, you're just getting the property to someone who has the means to clean it up, fix it up, so you can get it back on the tax rolls, which is what government doesn't normally have that ability.
Okay.
Yes, sir.
Yeah, just to follow up. Yeah. I mean, it sounds like a really good program, and trust me, I know that your county and my county has a lot of blighted property that needs this. So sounds like a good bill, and I'll support that. Thank you.
Thank you very much, Representative.
Thank you. Chairman Rudd, you're recognized.
Real quick question. I don't think you covered this. What happens that protects the person that's fixing the property up if the original owner comes back and wants to sue or wants a portion of the profit or something? Is there something there that protects them?
Yes, I know that answer, but can I have 1 second?
Yes, sir.
The owner gets 30 days after the receiver does their work to be able to buy the property or be reimbursed. Mhm.
Okay, thank you.
Chairman Rudd, okay. Chairman Crawford, you're recognized.
Thank you, Mr. Chairman. I move the previous question.
Previous question has been called for. Any objections? Seeing none, we're voting on House Bill 2567, moving on to full committee. All those in favor say aye. Aye. All those opposed, no. Bill moves on to full committee. Thank you, Chairman White.
Thank you, Chairman Committee, and appreciate your indulgence. Thank you.
We go to item number 4. House Bill 1968 has been rolled to final counter. That brings us up to item number 5, House Bill 2787 by Representative Barrett. Representative Barrett, you are recognized on your bill.
Thank you, Mr. Chairman.
We do have an amendment on that. Do you show an amendment code on that, drafting code?
015677.
That is what I had read all. Did I hear a motion on the amendment? Motion second on the amendment. All those in favor, you want us to put that on to make the bill, is that correct?
Yes, sir.
Okay. All those in favor of Amendment 15677 going on to the bill, say aye. Aye. All those opposed, no. We're back on the bill as amended. You're recognized, Representative Barrett.
Can I get a motion and a second on the bill too, just to make sure?
Okay. I thought we had. Do we have a motion on the bill? Motion, second? All right.
Okay.
Motion,
Thank you. I'm
second on the bill.
Sorry, Mr. Chairman, I didn't hear that. Just making sure we were good to go.
That's all right.
Ladies and gentlemen of the committee, this bill comes from constituents, particularly in Shelby County, that are looking to deal with a situation that they have in the building code there, where the building code is requiring sprinkler systems for residential properties that are 3 to 4 residential units. And so what we're trying to do is reduce the cost of that, because that's something that's really being built for affordable housing. And with in working in consultation with the administration and the fire marshal's office, that's where this amendment comes from, where we create some options and we limit the square footage of that as well. And Mr. Chairman, I do believe we have some people here to testify, so I'm happy to let them testify, and then we can get into the meat of the bill.
Thank you. Without objection, we will go out of session. And the first speaker I have is Mr. Ed Butler. Mr. Butler is in opposition to this bill, and you are recognized. And 3 minutes. Restrict who you are, please, sir.
Thank you, Mr. Chairman. Ed Butler. I am a fire sprinkler contractor, have been for 3 years, or for 3 years. I've been for almost 17 years this year. One of the issues I have with this particular legislation is, one, we're taking out fire sprinklers from multifamily housing. And unfortunately, you can never know who is living next door to you. They could be cooking meth, they could be doing whatever. And although this amendment allows for some 2-hour firewalls to be installed, I have been in numerous fires myself, or been immediately following the fire department being there. And a specific example, in 2022, had a 12-unit apartment building that had a cable box catch the curtains on fire, which is a very odd occurrence. And 2 sprinklers activated as they should, and the fire was extinguished in a 12-unit apartment building. Had that building not been sprinkled, there would have been 12 families that would have lost their home that night. I've been in a 4-plex with the same circumstances where they had a kitchen fire, 1 sprinkler activated and extinguished the fire in a 4-plex. And had those buildings not been protected in a multifamily application, those entire buildings would have burned down and all of those folks would have lost their home. So I would encourage you to not open this door and remove sprinklers from multifamily residentials. Now, I have talked to some of the folks that the sponsor is working with to offer some solutions. I know the amendment allows for a 13D system to be installed, and I think that would be a good thing, and put 13Ds in each one of those 4 units, which would help reduce the cost. There would have to be some concessions, I think, on the utility provider to be able to allow the sprinkler system and the domestic water to be coming off the same meter, which is allowed by code. So I'd be glad to work with them to help keep the cost at a minimum, but I would be adamantly opposed to removing those sprinklers completely, because I think in multifamily residential, you don't know what your neighbor's doing. With that, I'll be glad to answer any questions.
Any questions to the speaker? Seeing none, thank you, sir. We have one more that would that's here to speak on the subject in support. If he will come forward, please, Mr. Andre Jones, and give us his opinion on that. If you'll please just recognize yourself to who you're with, and you have 3 minutes, Mr. Jones.
Thank you, Chairman Carr. My name is Andre Jones. I'm with Jones Urban Development in Memphis. We are in support of this bill because we all know that affordable housing is something that we need across the state of Tennessee and this nation. And we're specifically talking about 3 and 4 family apartment buildings, triplexes and 4plexes. These types of buildings have not been built since World War II, simply because of the regulations and building codes that have made it too costly to build these types of buildings. We need diverse building types so that we can offer more affordable housing options. And we've worked with the State Fire Marshal's Office to cap the size of these buildings total to 5,000 square feet. We have single family homes that are much larger than that without sprinkler systems. I am currently building 4 4plexes right now, and it is a brain damage in essence. It costs up to $25,000 per building to add sprinkler systems, fire alarm systems, and fire protection connections. And if you're within a mid-block and you're not within 100 feet of a fire hydrant, you actually have to pay to have a fire hydrant installed if you're just building a triplex mid-block. So it's completely cost prohibitive. If this bill does not pass, then these buildings will never be built. And from a life safety perspective, it has been proven that smoke detectors are what saves lives. we have the option to put 2-hour fire separation between each unit. You have 2 hours, or the residents have 2 hours to get out of a 2,500 square foot building that's no more than 2 stories. So we've addressed life safety. We have the support of the State Fire Marshal's Office in this effort. The Home Builders Association of Tennessee is in support of this effort. And if we were able to provide more affordable housing options in the state of Tennessee by passing this bill, it will be a game changer. So I really appreciate you taking the time. And we're not talking about large buildings. We're talking about buildings up to 4,999 square feet and 2 stories. So I really would appreciate you voting in favor of this bill, and I think you'll see positive benefits from it.
Any questions to the Representative Thompson? You're recognized.
Thank you, Mr. Chairman. I'm sorry, Mr.
Jones.
Jones, so I thought. You said the state fire marshal is approved of this?
Yes, they actually drafted the amendment or helped come up with the language for the amendment.
Okay.
Representative Thompson.
Have you discussed this with the City of Memphis Fire Marshal?
Yes, the local fire marshal is on board. So John Zena, who is the Director of Planning and Development for the City of Memphis, has had those conversations with the City Fire Marshal. And actually, we passed a local amendment 2 years ago with the support of the local fire marshal that excluded sprinklers from 3 and 4 family buildings. The only reason why we're here today is because the State Fire Marshal originally stepped in and blocked us from doing that. So this has the full support of the City of Memphis, local authority having jurisdiction, which is the building official, the local fire marshal. We had a building code advisory board made up of engineers, builders, developers. We all agreed that to this amendment, to the exclusion of fire sprinklers being fine and not a deterrent or not having a negative impact on life safety. We've also had conversations with builders in Chattanooga, across the state, and they're all in support of this.
Representative Thompson.
Okay, one more question. Has it been determined what the effect would be on insurance for buildings like this with no sprinkler or fire alarm? Would there, are we talking about cost prohibitive insurance rates, or how does that work?
So we have not had specific conversations about insurance, at least I have not, but the size of the building. So currently I have a 2,000 square foot fourplex. That's 4 500 square foot units. So from a size perspective, it's much smaller than the standard size of a single family home. And so at this point, we don't see any potential issues from an insurance cost perspective. Is not being cost prohibitive in place of having sprinklers and fire alarm systems and all the maintenance that goes along with it. And it's an active system, meaning that it gives you a false sense of security, because if the sprinkler system, if it's in the winter and the sprinkler system freezes, or if there's a problem where the power goes out and the sprinkler monitoring system or the cell monitoring system that needs to be activated to make this stuff all work, if any of that is out of place or malfunctioning, then there's a false sense of security when we can just have a 2-hour fire separation that's passive that will really allow these folks to get out. So
thank you, Mr. Jones.
Thank you very much.
Thank you. Chairman Wright, you're recognized.
Thank you, Mr. Chairman. Before we get away from or get back in session, so I get my question out here. Somewhere in passing, I've heard that this depression, I guess, of not allowing 3-plexes, 4-plexes, some have been built, but it's been a small number, I've heard. Does anyone have that number of how many may have been being built? Or
in the city of Memphis alone, I asked our Division of Planning Development the number of building permits that have been applied to build a 4-plex since World War II, and the answer was none. Now, that's 2 over 2, 2 units over 2 units. Now, you can build what's considered to be a fourplex, but that's basically like a townhouse. You build them side by side with the 2-hour firewall. But that's not the type of building that we're talking about. We're talking about the types of fourplexes that you grew up with possibly in neighborhoods that had 2 units over 2 units or 2 units over 1 unit.
Chairman Wright.
Thank you, Mr. Chairman. And thanks for, a little light bulb came up here over my head because I can't hold it up, but I do have a diagram that does have with 1, 2, 3, 4
Yes.
that I've drawn on my piece of paper. But then you adding that this could be currently built 1, 2, 3, 4. Thanks for saying that. And thanks for the number because I thought the number was minuscule. Thanks.
Any further questions to the speaker? Seeing none, we'll go back into session. And Representative Barrett, you're recognized on your bill.
Thank you, Mr. Chairman. And I would just add to the testimony that you just heard that this bill is modeled after a law that passed in North Carolina last year. And just to highlight some of the differences between the two laws, the North Carolina law mandates 3-family and 4-family dwellings to be under the scope of the residential code statewide. And this law is only giving local governments the option. They have the ability to opt in or opt out of this requirement. The North Carolina law prohibits requiring automatic fire sprinklers in 3-family and 4-family dwellings, and Tennessee's law allows local governments the choice to require it or not. North Carolina requires or prohibits fire separation greater than 2 hours. Tennessee law says that's the minimum standard. So we're trying really hard here to give cities some options to be able to meet the needs of the people in their community to create affordable housing, as we know is becoming much more and more an issue for us to deal with. So with that, Mr. Chairman, again, I will stand ready to answer any questions.
Any questions of the sponsor? Previous question has been called for. All those in favor of House Bill 2787, moving on to full committee, say aye. Aye. All those opposed, no. Bill moves on to full committee.
Thank you, Chairman and
Mr.
Committee.
Representative Barrett. That brings us down to item number 6, House Bill 2055 by Chairman Eldridge. Chairman Eldridge, you're recognized. Second.
Thank you, Chairman and Committee.
Thank you. I believe we have a drafting code on that. Do you have a drafting code on that?
We do, sir. It's 015673.
All right. We got a motion second on the amendment. You'd like us to place that on the bill before we start?
Please, sir, it makes the
All right.
bill.
All those in favor of Amendment 15673 going on the bill, say aye. Aye. All those opposed, no. We're back on the bill as amended. You're recognized.
Thank you, Chairman. Members, this bill is seeking to do 3 things. It comes to us from the assessors of property. It also authorizes the assessor to determine permanent value of records. It will allow for tax maps and other documents to be electronically scanned by the Register of Deeds office using the funds allocated to preserve permanent value records that originate in the assessor's office. Second, it does modernize a definition dealing with movable structures. This will clarify for the assessors how to deal with movable structures that are constitutionally required to be assessed based on their use. And last of all, it authorizes a continuous review cycle for visual inspection that will allow for counties to save money when the State Board of Equalization approves this use. And with that, that pretty much sums up what the bill does, and we would appreciate your support.
Any questions to the sponsor? Seeing none, I guess we're ready to vote on House Bill 2055, moving on to full. All those in favor of House Bill 2055, moving on to full, say aye. Aye. All those opposed, no. Bill moves on to full committee. Thank you, sir.
Thank you, Chairman and Committee.
Item number 7, House Bill 2249 by Representative McCammon. Representative McCammon, you are recognized. By the motion and second, and I believe you do have an amendment with that.
Thank you, Mr. Chairman. Yes, I do. It is Amendment 014107.
All right. I got a motion and second on the amendment. We'll place that on the bill first. Okay, all those in favor of Amendment 14107 going on the bill, say aye. All those opposed, no. We're back on the bill as amended. You're recognized.
Thank you, Mr. Chairman. Members, House Bill 2249, as amended, essentially would prohibit HOAs from foreclosing on a person's property for non-payment of a special assessment. The special assessment is for the addition of a non-essential community non-official community amenities such as a pool, clubhouse, or a tennis court. This prohibition does not apply to essential amenities necessary to the regular and daily functioning of the community. Also requires that for any special assessment of a non-essential amenity, the board must pass the assessment by a 2/3 vote and then must provide members with financing or payment plan options. And with that, I stand ready for questions.
Any questions of the sponsor? Representative Thompson, you recognized.
Thank you, Mr. Chairman. So to not have or to do away with a non-essential amenity would require 2/3. Is that correct?
You recognize, Mr. Cameron.
Thank you, Chairman. Representative Thompson, if I'm understanding, you're asking if it would take 2/3 to do away with the.
Please, I'm sorry, I may have misunderstood.
Sure thing,
Yeah.
Mr.
You
Chairman.
recognize.
Essentially, what it would do is require a 2/3 vote in order to put a special assessment in place for a non-essential. So if the HOA wanted to build a pool or clubhouse, it would just take 2/3 majority of the board.
Representative Thompson, you recognize.
Now, with my experience with HOAs, 2/3 of the total membership is an extremely high bar. That's almost impossible to achieve. Typically, an HOA meeting or a few residents, and even when you have an important issue, something more important like this, for instance, you're going to have to even with the efforts of the board, HOA board, getting people there, it's still almost impossible to get even 2/3 there, much less a 2/3 vote.
If the chair may take a personal privilege here and correct me if I'm wrong, this 2/3 vote of the homeowners association to put us an assessment for a non-necessity, this is applying to somebody that was already in the subdivision before the subdivision was made and the homeowners association was created, trying to put a debt back upon them. Am I correct on that?
Correct, Mr. Chairman. Where this came out of, it came out of one of our residents in Williamson County. And she was a retired individual on a fixed income, had lived there well before the association came to be. The association came out and said that, well, we want to build a pool and we're going to assess you $30,000. She said, well, I can't afford that. She would have to sell her house. And essentially this is saying, well, the HOAs, you'll have to pass, not with membership necessarily, but just with their board of the HOA board. And that's not the entire, they have to convene with a quorum anyway. They would have to pass with a 2/3 majority to level a special assessment. And they can't foreclose on the house for a special assessment that's not essential for the functioning of the community. I hope that answers any clarification.
Representative Thompson?
Okay, I mean, the amendment says 2/3 of the total members of the homeowners association.
That is correct. It does.
It didn't say the board, it said the total members, and that's, so if you have 1,000 people, you're going to have to have a vote of 667 people to vote for it.
You recognize.
Thank you, Mr. Chairman. And yes, sir, you are correct. Clearly, I need another cup of coffee because I misread. Yes, it would be a 2/3 of the membership.
Okay. Again, I understand what you're saying and everything. I just think this bar is way too high, and it, of course, it's coming to you from someone in Williamson County, but it's going to affect the entire state. And I'm thinking of the HOAs in my district and the difficulty they've had in getting enough members to get things done. So because of that, I'm voting no on the bill, but I would hope that maybe you would consider the bar and everything and maybe lowering it somewhat. Thank you.
Thank you. Any other questions to the sponsor of the bill? Seeing none, we're ready to vote on House Bill 2249, moving on to full committee. All those in favor say aye. Aye. All those opposed, no. Bill be recorded. See the clerk to be recorded as a no. House Bill 2249 moves on to full committee.
Thank you, Chairman and Committee.
Thank you. Item number 8, House Bill 1715 by Representative Freeman has been moved to the Veterans Calendar. That brings us to number 9 on the calendar, HB 2337 by Representative Pearson. Representative Pearson, you are recognized. I got a motion. Do I hear a second?
The joy.
Asking for a second. Asking for a second. Seeing no second, bill fails. We move on to item number 10,
Thank you, Chairman and Committee.
House Bill 2342. You have the next one too, Representative Pearson. Motion. Do I hear a second?
Somebody's going to support this one, I'm sure of it.
Last call for a second. Seeing none, House Bill 2342 fails. Thank you, Mr. Pearson.
Thank you so much, Chairman and Committee.
Thank you. That moves us on to item number 11, House Bill 1980 by Chairman Wright. Chairman Wright, you are recognized from your seat.
Thank you, Mr. Chairman, for being recognized as I can sit here and read this.
Motion.
Got a motion, a second. I see that you have an amendment. Is that correct? I'm showing it to be 14621. Is that correct?
Motion on the amendment.
Motion been voted on the amendment. Second. All those in favor of putting the amendment 14621 on the bill, say aye.
Aye.
All those opposed, no. We're back on the bill as amended, sir. You're recognized.
Thank you, Mr. Chairman, for keeping up with my paperwork.
You got it.
This is going to be the most complex bill that I'll present this year. It comes from us. It comes to me to carry in the House from my Senator Becky Massey. The legislation is filed on behalf of Presbyterian Homes of Tennessee, which is a not-for-profit, exempt from federal taxation 501c3 of the IRS code. The entity wanted to take over Shannondale Homes.
Right.
And they added 2 lots and built some buildings approximately 3 years ago. In the interim of this, their paperwork got tangled up, just as my tongue is tangled up on trying to read their paperwork. So they built a location called the Lodge. It's the former site of the retirement home. It added 2 lots.
He's got to present a bill.
Oh, he's got a.
Yeah, you got to present a bill.
In this tangled up mess of paper, property tax was overlooked. And what this bill is seeking to do is straighten that out. Shannondale has filed new application for property tax exemption for 2023. That's been approved by the comptroller in charge, being in charge of the 501c3 part of it. But the negotiations between Knox County and the city of Knoxville has been worked out, and I'll skip to the last sentence of this. This bill is the support of Knox County, which has worked with Shannondale in the drafting of this legislation. The city of Knoxville is neutral on the legislation, and the Senate passed it out of committee 7-2, and I'll be seated now for intense questioning.
Any questions to the sponsor? Personal privilege from the chair. It's actually just like trying to get back that 1 year's tax payment. Is that not correct, Chairman Wright?
That's correct. A tax that they, when notified, they have paid, but they're in the negotiation of trying to get this worked out.
Okay. Any questions to the sponsor? Question has been called on the bill. All those in favor of House Bill, well, I just lost it. 1980. Is that right? House Bill 1980, moving on to full committee, say aye.
Aye.
Aye. All those opposed, no. Bill moves on to full committee. The next item on the agenda is House Bill 2623 by myself. I'm going to pass the gavel over to Chairman Wright, and I'm going to present from the podium.
Well, I have a motion and second. Bill's properly before us. House Bill 2623. Chairman Carr.
Thank you, Mr. Chairman. I do have an amendment with that. It's a amendment, I'll get to it in a minute, just like everybody else.
Does it look like 14174?
That is it. Yes, sir.
Motion on the amendment. Second.
Have a proper motion second on the amendment 14174. Does this need to be attached? Is this the bill?
It does not make the bill, but it can be attached. It's just some clarification.
Okay, we'll move forward with attaching the amendment to the bill. This is Amendment 14174, being attached to House Bill 2623. All in favor, say aye.
Aye.
Opposed, no. The amendment is attached. Chairman Carr.
Thank you. On the bill now, of course, as I said, the amendment does not make the bill, but it is part of, for explanation. You know, it's getting harder and harder for us to build and develop with these attainable homes. And what this would do, this would allow cities and towns another tool to increase attainable housing availability. The incentives would likely include reducing the number of required parking spaces, reducing setback requirements, allowing additional floors, or modifying density requirements. Now, this is completely permissive. They can do this if they want to, but they must come up with a plan, and the plan has to be approved by the cities, has to be approved by the builder and everything. And it actually asks the cities or municipalities to establish a voluntary attainable housing incentive program. But the amendment simply limits the types of structures or facilities that may be included in such program to multiple family housing of 5 or more units. The amendment defines multifamily housing to mean a building or a facility that includes at least 5 attainable rental units. And it's very permissive, but we think that if the planning commissioners would get together with the cities and give us a little more leeway on how we have to build and on the property, on the lot, and the setbacks and everything like that, it would be there. We'd be able to obtain more and make more of attainable houses. And with that, I stand for any questions.
Reedy. Chairman Reedy.
Thank you, Mr. Chairman. In reading from the amendment, Chairman Carr, it says it mandates property owners to submit applications for multifamily housing development to the Regional Planning Commission or Municipal Planning Commission. Can you expand on that?
Yes, sir.
Chairman
What
Carr.
that's doing?
Yes, sir. Well, you got your municipal planning commissions, okay? And they take care of what's inside the city. But we still have some out there that's under the urban growth boundary, and that would be the Regional Planning Commission. And the Regional Planning Commission could actually be just outside the city, but it's still within that urban growth boundary of the city.
Thank you, sir.
Thank you.
Chairman Rudd.
Thank you. Mr. Chairman, is this very similar to the successful program they've been running in Texas?
Chairman Carr.
Thank you. Pretty close. Yes, sir.
Okay.
Yes, sir.
I thought it sounded very familiar.
It's very familiar,
All
but
right.
I'm sorry.
Other questions, sponsor?
No.
If there are no other questions to the sponsor, we're voting on House Bill 2623. All in favor of sending House Bill 2623 to full local government, say aye.
Aye.
Opposed, no. Motion carries.
Thank you, Chairman and committee.
Moves forward to full local government. I could just adjourn, right?
That concludes our calendar for today. If there's anything else from the committee before we adjourn, I would just like to announce that next week, March the 20th, we will have our veterans calendar. Plus, we'll also have a calendar that time also. And next week is the last week to put any bills on notice because our final calendar will be March the 27th. Seeing none, do I hear a motion to adjourn? We are adjourned.